Good afternoon, everyone, and welcome to our webcast. This is a webcast on Patent Office post-grant contested proceedings, new challenges, and new opportunities. It, as you can see, is part of the New York State Science and Technology Law Center Spring 2013 webcast series. It's a little bit past spring, but as you know, we moved the date of this webcast originally following the loss of Ted Hagelin. And I just would like to once again express, and I know we all feel the same way, the tremendous loss that we've felt here at the College of Law, and we're going to try to carry on his work in his honor. So with that introduction, I'm Lisa Dolak. I am the Angela S. Cooney Professor of Law here at the Syracuse University College of Law, and I teach courses here on patent law. I also do some litigation consulting work and have become very interested in these particular new proceedings. And there's a lot to learn here, and I've got a lot of content that I hope to move through. I will warn you, I'll have to move through it fairly quickly because I definitely want to get to some of the points at the end. But you'll have the slides, you'll have the presentation, and I will commend to you the statute, the rules, and on virtually a daily basis, we're getting decisions out of the new Patent Trial and Appeal Board regarding these proceedings. So there's a lot of new material to digest. We have 4 new contested proceedings: inter partes review, post-grant review, what's called the traditional post-grant review for covered business method patents, and derivation proceedings. And I'm going to speak briefly about each of these. The first 3 are certainly post-grant review proceedings for issued patents. In other words, the derivation proceedings might involve a challenge to either a pending application or an issued patent. These proceedings are all adjudicated by what is now called the Patent Trial and Appeal Board. On September 16, 2012, the new Patent Trial and Appeal Board came into being, and it replaced the formerly known Board of Patent Appeals and Interferences inside the U.S. Patent and Trademark Office. The Patent Trial and Appeal Board's jurisdiction, or it's referred to as the PTAB, I will refer to it as the PTAB. Some people call it the PTAB. I find that to be a little bit irritating, but so it's the PTAB to me. The jurisdiction is the ex parte appeals, in other words, appeals from examiner rejections in original prosecutions, reexaminations, and reissues. Also, the board will continue to hear and decide the so-called legacy inter partes reexaminations and interferences. These proceedings are no longer being instituted under the AIA, but there are several that are continuing to progress through the Patent Office. So they have to be decided, and this is part of the PTAB's jurisdiction. There are also these new contested proceedings. So this is what the PTAB is doing. Just a word about the PTAB. The USPTO plans ultimately to bring the total number, plans to bring the total number of trial judges to about 220 by the end of 2013. The office has been rapidly hiring these folks to fill all these new spots. The AIA brings a great increase in workload to the board inside the office, and so these judges have been and are continuing to be hired, and they have been selected from places such as the USPTO Examining Corps, the Office of General Counsel inside the Patent Office, other government agencies, other administrative law judges, for example, have moved, and other attorneys from other government agencies, and from private practice. These judges, many of them have significant private and practice and government experience. They are quite knowledgeable, and for that reason and many other reasons, this is not your father's USPTO board. These judges work in Alexandria, Virginia, many of them, but some have also begun work in the 4 satellite offices of the U.S. Patent and Trademark Office, which are in Detroit, Denver, Dallas, and out in Silicon Valley. So a brief word about derivation proceedings. We don't have any of these yet because these are available to challenge applications that are filed under the new first inventor to file regime and we have only had that regime in place since March 16th. So there's a lot we need to learn about these, but this is the solution to the problem of, we're now, as of March 16th, under a first to file regime, essentially. And so basically stated the first inventor to get to the patent office with their application will win the race for the one and only patent that will be granted on a given invention. And so what happens if your invention is stolen from you, derived is the word we use in the law, and someone else steals your invention and files first? This is your solution. And it is the first inventor to file regime's replacement for interferences. It is available. These derivation proceedings are only available to people who apply for patents, and only within a year, and this is the language of the first publication of a claim to an invention that is the same or substantially the same as the earlier application's claim to the invention. The point is, there is a limited period of time in which you can, if you believe you are in the situation of having your invention stolen, there is a limited amount of time under which you can avail yourself of this remedy. What do? You file a petition, and we're going to be talking a lot about petitions today because that's how all these proceedings start. And once you file a petition, the board may or may not, will or will not institute a derivation proceeding, and what will determine whether a proceeding is instituted is whether this standard has been met. The petition is required to, quote, set forth with particularity the basis for finding that an inventor named in an earlier application derived the claimed invention from an inventor named in the petitioner's application, and without authorization, the earlier application claiming such invention was filed. So there has to be particularity, there has to be a basis for a finding, and that is carried through in the requirement that the petition be supported by substantial evidence. The PTAB has the authority to defer action on a petition until basically a patent issues, including the claim that is the subject of the petition, and in fact until 3 months after the patent issues. So it can basically, even if your petition is satisfactory, it can still put you on hold, or until a ex parte re-exam, inter partes review, or post-grant review involving the patent of the first applicant, the defendant, in other words, in the derivation proceeding, has been terminated. And if the board has instituted one of these derivation proceedings, it can stay one of these proceedings until basically we find out whether or not the earlier applicant is even, if there's another reason to deprive the earlier applicant of its patent, in whole or in part. Furthermore, even if your petition, once your petition has been accorded a filing date, the USPTO will hold the petition until your claim is otherwise in condition for allowance. So there's not going to be a derivation proceeding if until the office determines that you have patentable subject matter, just to not waste time and money. Turning now to post-grant review, these are, at least a species of these are underway. None of these yet have been filed, these proceedings themselves. The covered business method version of this proceeding have been filed. And the reason why is, again, the post-grant review is available only as to patents whose challenged claims have an effective filing date of March 16, 2013 or later. So post-grant review, in other words, is available to attack the so-called first inventor to file patents. Now, although none have been filed as of yet, because I don't even know whether any of these patents have issued, you might say, well, how could they have issued? It's only been, whatever it's been, 3 months, I guess. And so they probably haven't issued. But you shouldn't expect that it will be as long as 3 years or 4 years until we start to see these, because of all the various new fast-track examination proceedings that are available, or routes that are available in the office. And so some of these first inventor to file patents may be issuing within 2013. And so we should start to see some post-grant review, or we could start to see some post-grant review proceedings initiated relatively soon. Once these patents, the first inventor to file patents, issue and are vulnerable to attack under post-grant review, they are only vulnerable to PGR within 9 months after their issue, or, and in the case of a reissue application and patent, the reissue date. And so this is the limited window, and there is, under our law, only one window. There was a lot of debate during the lead up to the AIA about whether there should be 2 windows. There is only one window for post-grant review, 9 months after the issue of the patent. There is another significant limitation on the institution of post-grant review to challenge the validity of an issued U.S. patent, and that is if the petitioner, the challenger, has already filed a civil action challenging the validity of any claim of the patent before filing the petition, PGR may not be instituted. So you basically have to pick your poison as far as a challenge to the patent. And of course, you can only file a civil action challenging the validity of a claim if you have standing to do so, right? There has to have been some sort of action by the patent owner to put you in a position where you have standing in order to challenge in federal court, whereas those standing requirements don't apply to regular old post-grant review. And anyway, but so for some people, post-grant review will be the only option. If you are one of those people who has the option of filing a civil action to challenge the validity of a claim of the patent, then if you do so, you give up your right, basically, to file a post-grant review. The estoppel provision, what happens if you do file a post-grant review and that post-grant review goes to final written decision before the PTAB? You are then estopped from raising in any subsequent USPTO, district court, or International Trade Commission proceeding any ground of attack that was raised or reasonably could have been raised in the post-grant review. This is a very, very broad estoppel. It's broad because of content we'll show on the next slide. It has to do with the fact that the grounds for post-grant review are quite broad. There was some talk about perhaps scaling this estoppel back in some sort of post-AIA technical amendment. It didn't happen. So this is a very broad estoppel, but it is only triggered by a final written decision by the PTAB. So we'll talk about that a little bit too. What's the standard for getting your post-grant review petition granted? The standard is the petition must show that it is more likely than not that at least one challenged claim is unpatentable. That's the standard. More likely than not that at least one challenged claim is unpatentable. Or the PTAB has the authority to institute post-grant review based on a petition that raises a, quote, novel or unsettled legal question important to other patents or patent applications. So there is this sort of second safety valve route that the board has if it sees something or if it accepts the petitioner's argument that that there is this novel or unsettled question. But in the main, we can expect these petitions to be granted or denied based on the board's application of this more likely than not standard. The grounds: any invalidity defense available under 35 U.S. Code Section 282, which includes non-statutory subject matter. And we've already seen, as I will point out, we've already seen in the covered business methods species of post-grant review, which is underway at the Patent Office, we've seen the first final written decision of the board declaring invalid for lack of subject matter eligibility the claims of a patent. Anticipation, obviousness, lack of written description, non-enablement, these are all validity defenses under Section 282, effective September 16, 2011, the first effective date of the AIA. Best mode, failure to satisfy best mode is no longer available as a defense to the validity of a patent, and so best mode is also not grounds for the institution of post-grant review. Also, double patenting is not a basis for the institution of a post-grant review. Switching over to inter partes review, we've seen a lot of these. We are up in the mid 300s or so of these have been filed since September 16, 2012. These are available as to any patent. So that's why we've seen so many of these. These will be available to challenge pre-AIA patents, post-AIA patents. So that's a distinction between inter partes review and post-grant review. But once they are available after the later of 9 months after the challenged patent's issue or reissue, or the date of the termination of a post-grant review if one has been instituted. So once there are post-grant review, once there are patents being issued that can be challenged on post-grant review basis, inter partes review petitions will have to wait until that 9-month initial window has closed, and even longer if a PGR has been instituted. They'll have to wait until the date of the termination of the PGR. So the PGR basically will, these proceedings are designed to be stacked, essentially. And so, but again, the patents that have the 350 or so of these that have been filed to date, probably more, it's probably around 360 or 70 as of as I sit here today. These have been filed against pre-AIA patents, and so the 9-month window isn't relevant to those. There are limitations on your ability to institute an inter partes review or to use the inter partes review tool if you have filed a civil action challenging the validity of a claim of the patent before you file the petition. Same as with PGR, IPR may not be instituted, so you have to pick your poison. Furthermore, if you have been sued and more than a year has passed since you were served with a complaint, not filed, served with a complaint, charging infringement of the subject patent, then your opportunity to use inter partes review against that patent has passed. And then, and that's an important limitation that applies to inter partes review. Furthermore, and this is kind of this third bullet here, is an example of part of the estoppel operating. You cannot have an inter partes review instituted on any ground that the petitioner raised, that you raised or reasonably could have raised during a prior inter partes or post-grant review, including a covered business method proceeding, that resulted in a final written decision. And so we'll talk more about that estoppel in a moment. I see there's a question.
Does estoppel from PGR affect only the actual petitioner, or does it stop other persons that are in privity with her?
It will affect you and your privies. And for that reason, all the rules that govern the filing of these proceedings require the petitioner to identify, and the patent owner for that matter, but the petitioner to identify the real parties in interest and privies. And there is guidance, at least, in the relevant rules to give a sense of what the board thinks those mean, what the Patent Office thinks those mean. But yes, you and your privies are estopped. Again, more about the estoppel and inter partes review. A final written decision in IPR stops the petitioner from raising in a subsequent USPTO, district court, or ITC proceeding any ground that was raised or reasonably could have been raised in the IPR. It's the same statutory language as the estoppel for PGR, but the estoppel is necessarily narrower with inter partes review. Why? Because the grounds are narrower. As you can see at the bottom of this slide, inter partes review may only be instituted based on anticipation or obviousness based solely on patents or printed publications. So it's not even anticipation broadly. You cannot institute an inter partes review, request an inter partes review based on anticipation from a pre-critical date sale or a pre-critical date public use. This you should think about re-exam, right? Re-exam is limited to patents or printed publications. Inter partes review are limited to patents and printed publications. And so those are the only grounds that you could reasonably have raised in the inter partes review. And so the estoppel here is broad, but it's narrower than that for PGR. For granting the petition, the board will only institute a proceeding upon review of a petition if the petition shows that there is a reasonable likelihood of prevailing on at least one challenged claim. And so it's a different standard than PGR. Some people say it's broader, some people say it's narrower. You can argue it both ways, but it is a different articulation. There's a reasonable likelihood of prevailing on at least one challenged claim. So the final type of proceeding is the transitional program for CBMs. This was created by Congress in an effort to give parties who have been sued for infringement of business method patents an opportunity to have a patent office post-grant proceeding that would be broader than inter-parties review. Because remember, inter-parties review is only available based on patents or printed publications. Congress thought, apparently, that there are too many invalid business method patents out there and that people are being sued for infringement of those business method patents, some by the so-called non-practicing entities, otherwise known as the patent trolls. And so this was a vehicle, or this was clearly a strike against that problem, that perceived problem or that problem by Congress. So it's a form of post-grant review. It's supposed to sunset ultimately once post-grant review gets up and going, although there is a bill pending in Congress that was introduced in Congress that would actually make these CBM proceedings permanent and actually expand the definition of what constitutes a so-called covered business method patent. But let's not talk about what might happen. Let's talk about what already has happened. So what is a covered business method patent? Well, the basic definition is a method or corresponding apparatus for performing data processing or other operations for financial product or service. There is more guidance on this in some of the PTAB decision area, so I'm going to just stop with that. I will point out that if it's a true technological invention, it is not subject to covered business method review. So these CBMs are available for any covered business method patent, pre-AIA or post-AIA, except for the post-AIA, the first inventor to file patents, for the first 9 months after issue. In other words, while they are susceptible to PGR, Congress says that's good enough. So that's the limitation there. And there is this very important limitation: only petitioners who have been sued for or charged with, I should say, it's broader than sued for, it's sued for or charged with infringement of the patented issue can petition for CBM. So another way of saying that is if you have not been sued for or charged with infringement, you are not eligible to bring a CBM, to file a CBM petition. Furthermore, again, within 9 months of the issue or reissue, if the patent is a first inventor to file patent, your option is to proceed through PGR instead. You also cannot, the board cannot institute a CBM on any ground that you raised or your privies raised or reasonably could have raised during a prior inter-parties or post-grant review, including a prior CBM. So there's an estoppel that takes effect here. That resulted again in a final written, in other words, a final written PTAB decision. So the linking theme here is estoppel only attaches upon the board's final written decision. So you cannot endlessly bring these CBM proceedings against the same patent by the same parties. In other words, so there is an estoppel. It is raised or reasonably could have been raised. But notice, CBM creates no reasonably could have raised estoppel as to subsequent district court or ITC proceedings. So that's a distinction between these and the IPRs and PGRs. Standard for grant of petition is the same as PGR. These are PGR proceedings. They're just a sort of special category. Congress let us get a head start bringing down all those nefarious business method patents out there. And the grounds are the same as PGR. Any invalidity ground, that does not include double patenting. So a little bit, so that's an introduction to the proceedings. The USPTO has to complete these proceedings by statute within 12 months from their institution, from the petition. And we'll talk in a minute about the way this proceeds. But if the board grants your petition in whole or in part and institutes a proceeding, the office has 12 months to get the proceeding completed with a 6 months good cause exception possible. But we're talking about an absolute outer limit of 18 months. And there's been some discussion about what happens if the board doesn't make that 18-month or that 12-month limit. And I was at or on a panel at a program about these proceedings, and the former PTO director, David Kapos, said that he thinks, and I think this is a good way to read the statute, that the board would just, and the office would just lose jurisdiction when that bell tolled. We haven't gotten close to that yet because the board has been speedily proceeding through these proceedings and has been doing, from everything we can read about from its decisions, doing absolutely everything it can do to fulfill the statutory mandate that these proceedings are to be a just, speedy, and inexpensive alternative to district court or ITC litigation. There is in the statute the option for the USPTO to limit the total number of IPRs that may be filed during the first 4 years on a sort of USPTO fiscal year basis, which will end at the end of September. So we're coming to the end of the USPTO year. The sort of default limit is, it's in the 200s, around 250 as I recall, but so far the office has not imposed that limit. As I said, we're up in the 360s. All told, we're up over 400 for these proceedings. And but on the IPR limit, so far the office has not exercised its authority to cut these off. But it could happen. I mean, it could happen. We don't know at any time. So there is a suggestion that if you want to file an IPR, you might want to get it in process sooner rather than later, before the office cuts them off if it decides to. Who can represent clients in these proceedings? The lead counsel has to be a registered practitioner, in other words, a patent attorney or patent agent. The pro hoc vice recognition can be granted by the board on a good cause showing for backup counsel. So you have lead counsel, you can have backup counsel, and the backup counsel can be a non-registered practitioner who is admitted upon motion to the board for pro hoc vice recognition. And one of the very first sort of exemplary orders that the PTAB issued is the order basically setting forth what has to be in those petitions for pro hoc vice, those motions for pro hoc vice recognition. And so, and as is the case with just about everything I'm talking about, there's probably a PTAB order on point, and that should be your template for any papers that are being filed before the PTAB. They basically are setting forth checklists, and they are rigorously enforcing them. All counsel, registered or unregistered, will be subject to USPTO ethics and discipline rules. The motion has to be, the would-be admitted attorney has to submit a affidavit basically agreeing to be bound by USPTO ethics and discipline rules. I mean, you might say, well, what can the USPTO ethics machine do to these people? Well, it could certainly prevent them from ever again participating, or for some period of time, participating in one of these proceedings. So there is some real teeth there. And the board has the authority to disqualify counsel for cause upon motion, just like it always has. This is the timeline. If you've looked at all of these rules or these proceedings, you've seen this timeline. It appears in the in the office's rules. And this just gives you a sort of graphic measure of what we'll talk about in a moment. But, you know, real quickly here, you can see the petitions filed. The patent owner has the option of filing a preliminary response within 2 months. The PTAB then has a maximum of 5 months from the filing of the petition to issue a decision on the petition. It will either institute or not institute the proceeding in whole or in part. The vast 90+% of these proceedings, the board has instituted them on, to some extent, typically cutting back the grounds significantly. In other words, refusing to institute proceedings based on what the board calls redundant grounds. But 90+% of these have been instituted. That starts a clock. Creates the patent owner's discovery period. The patent owner then has 4 months to file a response to the petition and put in its evidence, basically. And any motion that it has to amend claims, we'll talk briefly about motions. Once that's in, there's a 2-month petitioner discovery period, which gives the opportunity for the petitioner to reply to the patent owner's response, and if it chooses to oppose any claim amendments. Then the patent owner gets another month in order to deal with any opposition to the amendments and can reply to the opposition to the amendment, and then the oral hearing will be set on request. There will be an oral hearing and then ultimately a final written decision if these things go all the way through. What are the fees? They're on the slide. These things are expensive in terms of just the fees that are paid to the office. $9,000 petition fee for inter-parties review up to 20 claims, and then a separate $14,000 fee for the institution of up to 15 claims. So there's add-ons, of course, for more claims. Post-grant review, even higher, $12,000 petition fee, $18,000 institution fee. Some considerations pre-institution. There are page limits, and again, the board will strictly enforce these. This is not your father's re-examination proceeding. These IPR, you got to get it into 60 pages, PGR 80 pages, closely scrutinized by the PTAB panel assigned to the petition. Redundant grounds will be disregarded, and the petitions, for good reason, have for the most part been accompanied by expert declarations. That's essentially a requirement because the petition has to be based on evidence. Again, there's an option for the patent owner to respond. There are page limits imposed on that response, and the patent owner may not submit declaration evidence except in the interest of justice, which would have to be, you'd have to convince the board of that. But the patent owner can do certain things. It can argue that the petitioner is statutorily barred from pursuing a review. For example, because their year window, it's been more than a year since they were sued in the case of an IPR. The references asserted to establish that the claims are unpatentable are not in fact prior art. So you can see these are non-merits grounds. The prior art lacks a material limitation in all the independent claims. That's a merits ground, but basically you would be pointing to the prior art itself and saying that it defeats itself. You wouldn't be relying on expert testimony. The prior art teaches or suggests a way, again, merits argument. Petitioner's claim interpretation that the challenge claims is unreasonable, so you challenge their claim interpretation. And then there's another basis here for 101 grounds, another thing that the patent owner can do. Again, this was the data as of June 28th. The Patent Office includes an AIA statistics page, so you can keep track of how many of these are going. They update it, I think, once a month. As of June 28th, there had been 326, but now it's up in the 350, 360 range. Again, 90% grant rate. CBMs, there have been 31 requested, and most or all of them had been granted as well. Again, but not the kitchen sink version that the petitioner might have tried to squeeze into that 60 pages, or 80 pages, the scaled down PTAB version. This is an example of a decision. This is the cover page of a decision to institute trial for inter-parties review. I just put this up so that you could see what these board decisions look like, and they are, most of them anyway, are available on the PTAB's website. Although it's a little clunky, you need to know they're not word searchable. That's something I've wondered about why they can't be. So post-institution, again, we've kind of talked about this timeline, but just briefly, there's the patent owner discovery period, the petitioner discovery period, the patent owner's reply to any opposition to amend, and then the oral hearing and the written decision, again, with this ultimate 12-month limit from institution. Discovery. There is discovery in these proceedings. It comes in 3 categories, and I will talk about each of these briefly. There are authorized mandatory initial disclosures, but they're not really mandatory. They're optional because they only kick in if the parties agree to engage in this mandatory initial disclosure, or one party files a motion and gets the board to agree that there should be mandatory initial disclosures. There are 2 options described in the rules. One of them looks very similar to basically what you'd see in Federal Rule of Civil Procedure 26A, but there's another sort of the Patent Office's version of what might be included in these initial disclosures. But again, we haven't seen any of this because they're optional, and to my knowledge, nobody's using this. Routine discovery, however, is happening. First of all, the other side gets any exhibit that you cite in a paper or in testimony, and this applies to both parties. So if the petitioner or the patent owner refers to any exhibit, that has to be provided to the other side. You are also entitled as a litigant in one of these proceedings to cross-examine via deposition your opponent's declarants. And again, that's a two-way street. It's automatic. It's not, you don't need a motion. It's routine discovery. You're entitled to it. The third thing you are entitled to is relevant information that is inconsistent with a position advanced by the party during the proceeding. And you are not only entitled to, well, no, this is what you have to disclose. You have to disclose automatically, routinely, to the other side, any and all relevant information that undermines, the language is inconsistent with, a position that you are advancing during the proceeding. So you are required to shoot yourself in the foot here a little bit. There was a lot of complaints about this during the as the rules were being proposed and finalized. The office did narrow what you had to do here. As proposed, you not only had to disclose this information, but you had to explain it. But now you just need to disclose it. And furthermore, you need to serve it concurrent with the filing. Notice you're not filing it with the board. You're serving it on the other side. This information is not filed with the board. It is served on the other side for them to do with what they can. And you have to serve it concurrent with the filing of the documents or things that contains the inconsistency. So unless you've already served it. So it's just got to go right away. There is the possibility of additional discovery. For additional discovery for IPR, the standard is interest of justice. For PGR and CBM, the standard is good cause shown. Again, the final rules explain what the office thinks those standards mean, but basically don't count on it. The key PTAB decision here came out on March 5th, 2013 in this Garmin versus Quozo Speed Technologies IPR. And the board gave 5 interests of justice criteria that must be shown by the requester of additional discovery. And the board makes it very clear that it's not going to be easy to get. Amendments. We said the patent owner has the opportunity to amend. It is a limited opportunity for the patent owner to amend. This is not like ex parte re-exam. It's not like inter partes re-exam. First of all, you have the right to file. You do have a right to file, but it's the right to file a motion. So you have the right to file the motion, but you have to still make a showing in the motion that you're entitled to make the amendment. Presenting any new or amended claims, and in fact, although you have a right to do this, the rule says you must confer with the board before you file this motion. So you basically tell the board you're going to file the motion, and then the board will decide whether to grant the motion. And what will decide whether the board grants the motion for you to amend your claims? First of all, your amendments must respond to a ground of unpatentability involved in the proceeding, and you have to show why and how your amendment does this in your motion. There is a presumption that the board has put in place that you are entitled to only substitute claim for claim. You are canceling a claim, you can add one and only one new claim. If you want to add 2 claims, you've got to convince the board why you should be entitled to do that in your motion. If you decide you want if you subsequently want to file a motion to amend your claims, you may only do so upon the joint request. So you have to get the other side to agree with you to file this motion jointly, and the standard is that you're showing the board that this amendment will materially advance settlement. You cannot broaden the scope of your patent, and intervening rights will apply to any amendment just like they do in other post-grant proceedings. Furthermore, there is a patent owner estoppel here. The patent owner cannot, in inter partes re-exam or CBM or post-grant review, recover any previously disclaimed subject matter in any other proceeding, whether it's an earlier contested proceeding or a prosecution. You can't get, in other words, a claim that is not patentably distinct to what you've already disclaimed. So that's another significant limit on amendments. Oral hearing, that's in terms of the proceeding, and I realize I'm going fast, but there's just so much here to cover. So I apologize for that, and I hope to try to get perhaps to some questions. The first ever AIA contested proceeding oral hearing was held. It was in a CBM. It was on April 17, 2013. It was in this SAP America versus Versada Development Group. This is a CBM which, like most CBMs, well, all CBMs, and, well, not necessarily all CBMs, but most CBMs, if not all, and most IPRs, is a situation where the Patent Office's contested proceeding is concurrent with a pending district court litigation. And so that's this case. This was, as you can see, it was, the hearing was expedited. Again, this happened very quickly. I mean, this proceeding had been filed about, whatever, 6 or 7 months before the hearing. The hearing was expedited because the challenger agreed to limit its challenge to Section 101 grounds. The hearing was also broadcast live, and I have the links here to the transcript of the hearing, to the demonstratives that both parties used. I just thought you might want to see the kinds of demonstratives that the parties used in the oral hearing. The oral hearing was, I think, 2 hours long, basically an hour for each side. And so you can read the transcript. You can see, if you're interested in how, this is the sort of, although the whole proceeding is called a trial, and although the oral hearing, of course, doesn't have witnesses like a trial would, the oral hearing is kind of the analog to basically like a closing argument would be, I guess, in a trial. First final written decision was issued promptly thereafter, June 11, 2013. The time from petition to decision was 9 months. That's quite speedy. And because there had been previously basically it's a $400 million judgment against SAP in the district court, there is the possibility, depending on how the appeal goes in this CBM, that this judgment will be wiped out as a result of this proceeding. The PTAB, in its final written decision, which is worth reading, it defended its use of the Patent Office's broadest reasonable claim interpretation standard. It explained why we knew the board was going to use it. The board explained to us why it's important that the board use that standard. And of course, you know that a different standard, the so-called correct interpretation standard, or the Phillips standard, governs in litigation. It applied the recent Section 101 case law, and of course there's been a lot of that. And this is, again, a business method situation, so it was that case law. And it credited the petitioner's expert over the patent owner's expert. So you see the boards discussing the evidence. What about settlement of these proceedings? Well, they can be settled. In fact, I'm sure that the office would like as many of them as possible to be settled. The statute says the proceeding shall be terminated with respect to any petitioner. Okay, so basically, we can let a particular petitioner out. Let's think about it in terms of that. The proceeding shall be terminated with respect to any petitioner upon the joint request of that petitioner and the patent owner, unless the office has decided the merits of the proceeding before the request is filed. So what this statute gives is the opportunity for the petitioner to avoid the statutory estoppel. So the petitioner, if it settles with the patent owner, can get out and not be bound by any estoppel. The settlement can occur before the PTAB institutes trial or after the PTAB institutes trial. The petition and any cited prior art in that petition will remain public information, so that obviously hurts the patent owner to some extent, notwithstanding the settlement. And then importantly, the office does not necessarily have to stop its review just because it let a petitioner out. So the petitioner avoids the estoppel, but the office may terminate the review or proceed to a final written decision. And the board has indicated that it is unlikely basically to proceed to a final written decision if there has been a settlement of the proceeding, unless the claims, the board says, are clearly unpatentable and the owner has filed no response to the petition. So in which case the board is kind of providing a public service there. It sees claims that it believes, based on the petition, are clearly, and its own review, are clearly unpatentable. The owner has not filed any response to the petition. So the board may proceed to declare all or some of the claims to be unpatentable, invalid. The procedure for settling these proceedings, the settlement agreement must be in writing, must be filed with the PTAB. And by the way, it's not just the settlement agreement, the sort of one that you ginned up for the board, it's the actual settlement agreement, including any sort of side agreements that are part of the settlement agreement or referred to the settlement agreement. So the actual settlement agreements, all of them, have to be filed, have to be in writing and have to be filed with the PTAB. You can file it as business confidential information. Under the statute, it'll be available only to federal agencies on written request or to any person on a showing of good cause, and we, of course, don't know yet what that means. But many of these settlements have been filed, and the board has granted the request to treat them as business confidential information, although, as you can see, business confidential information is not a vault necessarily. And then you have to submit a joint motion to terminate. It has been suggested by some commentators that there is another option, which is to settle privately. Don't file your settlement agreements. Just tell the board you're not going to continue. Walk away. This would allow you to keep your settlement terms completely private. It would not. That would mean that the formal estoppel would likely attach because you didn't go through this procedure to get out from under the estoppel. But the sort of the reality there is that presumably any such settlement agreement effectively estops the petitioner anyway, right? What patent owner in their right mind would settle one of these without putting an effective estoppel in the settlement agreement? And it appears likely that the PTAB would still terminate these, so it's an alternative way out. Estimated cost, this is from this website. I don't vouch for these numbers. I just found these numbers, thought you might be interested in seeing them. As compared with the district court action, discovery $1.5 million on average, trial $1 million, total $2.5 million. Inter-parties review, it's been suggested you're looking at around $266,000 for the petitioner, $227,000 for the patent owner. Post-grant review, again, more grounds are available, and that accounts for the higher numbers here, $339K for the petitioner. Again, these are just ballpark numbers of what one of these proceedings might cost you. So the last part of the presentation, I just wanted to highlight some considerations for both petitioners and patent owners in these proceedings. This is where the kind of strategic thinking comes in. Although I will say to be able to utilize the strategies that are available here, it's imperative that you and at least your counsel thoroughly understands the great volume of material that is at stake here in terms of the rules, the statute, the board decisions. And really, this is rarefied air. And it's truly a specialized practice. And if you are not a practitioner who is investing what it would take to become an expert in these proceedings, you might well want to stay out of them, or at least partner with one of the number of specialized firms. This is not something to be undertaken lightly. No question, these post-grant proceedings, the design favors petitioners. There is no question that these are not patent owner friendly. This is not patent owner friendly territory. There are generally way more opportunities for petitioners and generally way more challenges for patent owners. So let's talk about some considerations from the petitioner's perspective. What are the petitioner's challenges? Well, these petitions require claim construction. You have to go in your petition. What we're seeing from the board is you have to go in with an articulated claim construction and the basis for that claim construction. And so that, you're boxing yourself in a little bit, obviously. Right out of the box, you need to take a position on what the patent owner's claims mean. There are page limits, and some of the games that people have played to try to get around these and the way the board has responded to those are quite interesting. And I commend, again, if you're going to do this work, make sure you understand how the board interprets its page limits rules. Especially in inter-parties review, because again, if you've been sued, you only have 12 months to get your inter-parties review instituted. You can't afford to have your petition kicked, have the 12-month clock run, and then try to come back in with one. The CBMs have a standing requirement. Again, you have to have been sued or charged with infringement. PGR, only 9 months within issue. IPR, only within 12 months of being sued. And then there is the estoppel. You can't be anonymous. You have to go in and identify the real parties in interest and all the privy. So there's no anonymity here like there is with potential for ex parte re-exam. And And in PGR, again, as we said, there's this very broad estoppel that Congress did not fix. The opportunities for the petitioner. The claims are given the broadest reasonable interpretation, which is generally, if not always, broader than the claim construction that you would get from the district court. So it is more likely that claims will be held invalid under a broadest reasonable interpretation construction than under a district court construction. The patent owner enjoys no presumption of validity in these post-grant proceedings. The burden of proof is preponderance of the evidence, not clear and convincing evidence that would apply in litigation. PGR, the grounds are not limited to prior art, so that's an opportunity to challenge claims based on non-enablement, lack of written description, ineligible subject matter. The CBM's very limited estoppel, at least as to the district court and ITC proceedings. Remember, it's only as to the grounds that were raised in CBM. And there are no litigation timing limits in CBM. There is obviously these are much less costly as compared with district court challenges, although it's still a significant cost. And there is an improved chance for stay of co-pending litigation as compared with inter-parties reexamination, many of which just went on forever, and ex-party reexamination, some of which went on for even longer than forever. And we're seeing that with the stays, although we're not seeing, and there's a whole body of law that's being built up around these stays, and I don't have time to cover that right now, but if you're thinking about asking for a stay in a co-pending litigation, you should dig into that because it depends on the stage of the proceedings and lots of other factors as to whether you are likely to get stay. From the patent owner's perspective, what are the challenges? Again, no standing requirement. So patent owners can be picked off just sitting there. Your patents can be dragged back into the patent office. This is not like district court litigation. This is critically important. And as we see the first inventor to file patents start to issue, again, of course, the patent owner doesn't know this challenge is coming, right? The petitioner knows that the petitioner is planning to file a petition. Most patent applications, as you know, are published, and so the petitioners can see what's coming and can gear up for these things and have months and months and months to prepare and then drop this on the patent owner who doesn't even see it coming. This has significant budgetary implications for patent owners who must budget for the possibility that their patents will be picked off immediately upon issue by someone who has not been threatened or sued and in a big hurry be forced to defend the validity of their patents under this very tight time crunch. For universities, in particular, for state universities, that is, state universities enjoy no sovereign immunity in the patent office like they do in the district courts, and so they are vulnerable to these. This is really important, and a lot of people I don't think understood this about these proceedings because we're used to, for example, in ex parte reexamination, we know the standard is a substantial new question of patentability. And there's a lot of law about what that means, but it has to be a new question at bottom. Here, the grounds need not be new. You can be challenged in these post-grant proceedings on art that has already been vetted by the examiner, and you got your patent over that art. And the board might well take a different view of that art. Remember, this is a board of a highly trained, experienced, technically trained lawyer, or not necessarily lawyers, but many of them were lawyers, versus a single overworked examiner. And so, again, the grounds here need not be new. These are the significant challenges that patent owners face. And as I explained, you have a very limited opportunity to amend your claims, and you are subject to patent owner estoppel, as we've discussed. Both parties need to keep in mind the speed of these proceedings. This is a particular challenge, as I was just explaining, for patent owners because patent owners don't control the timing. But as I said, patent owners must plan and budget for PGR and IPR attacks. Both sides need to know, and this is good news. There is some good news for patent owners here. The PTAB is closely scrutinizing these petitions, and as I've said, is not letting petitions get through, is not instituting trial based on multiple redundant grounds. And this is forcing petitioners to engage in very targeted, serious, well-supported attacks. There is, for both sides, the opportunity, as I said, to cross-examine the other parties' declarants. The judges are technically trained patent experts, or they're rapidly becoming patent experts. And there is, as I said, for the reasons I discussed, the need for specialized counsel. And somehow, talking very quickly, I've managed to get us in under the hour time period. I don't see any questions other than the one I've already asked, but let's see. I see one. The question is, from a business standpoint, what would prompt a party to take this road versus the district court? Seems you give up a lot in doing this regarding estoppels, restriction, claim construction. I can't see the rest of that question. I click on it. It's modern technology. No, it actually took it away entirely.
So it says, is it just cost? Is it just the same limit idea of a specialized patent review proceeding? A kind of waste since we have the specialized judges in the sense?
Yeah, I mean, again, I can't even see the question here, but as I understood the question was, what would motivate a petitioner to go this route? Well, obviously, patent owners can't go this route. They just have to sit back and let it happen to them. But again, the estoppel, I don't think is that big of a deal in the sense that there were estoppels, first of all, for inter-parties re-exam. So if that was your possible alternative. And you have to take your best shot somewhere, right? And so you only really get one shot at the patent owner, whether you go whichever route you choose. These are obviously significantly less expensive. You don't have the just wide open discovery that you have in district court, and that may be something that is appealing to petitioners. And again, the odds are stacked against the patent owners because of the broadest reasonable interpretation. I remember the question referenced that. That's a significant advantage, and we're seeing that. In the board's decisions, even some of the preliminary decisions in some of these cases that haven't been finished. And there is the lack of a presumption of validity and the lower burden of proof. I mean, those things are all worth a lot, I think.
There's one last question. It says, regarding the CBM in the standing requirement, sued or charged with infringement. And then it says broader or the same as in Red Wing Shoe, where an infringement notice letter is not enough?
I don't know the answer to that question. That's something I would have to research. And the question, by the way, which I guess I should repeat, was is the standing requirement for CBMs, which is that you have to have been sued or charged with infringement, is the charged with standard the same or different from the Red Wing Shoe decision? And I honestly don't know the answer to that. I would have to research whether what has been said in the statute as well as in the rules that the office put out for those CBMs. There's something I'd say about the rules. Each of these proceedings has its own set of rules, but you don't want to stop there because there's also the sort of general, what's called the PTAB trial guide and the PTAB trial rules. And so don't assume there's only one set of rules to be reviewed with regard to and there's lots of appendices too. Well, it's 12:59. I don't think we have any more questions. And now it's 1 o'clock, and so with that, I really appreciate the chance to talk with you today, and thank you very much for participating in this webinar, and I hope to see you on another one again soon. Thank you.